Ladies and gentlemen, without further ado, I want to introduce to you our keynote speaker. And we are really honored, ladies and gentlemen, to have with us Honorable Justice Isaac Lenaola, CBS, SCJ, that is a Supreme Court judge. Justice Lenaola is an alumni of the University of Nairobi and the Kenya School of Law. After admission to the bar, he practiced law in Nairobi, specializing in commercial law and land law, and served as a commissioner at both at the People's Commission of Kenya and the Constitution of Kenya Review Commission, CKRC. Justice Lenaola also served as a member of the tribunal investigating the conduct of puin judges. He joined the judicial service in 2003 and worked as a resident judge in Embu, Meru, Machakos, and Kakamega High Courts. As a High Court judge, Honorable Justice Lenaola also served as a commissioner at the JSC, that is a Judicial Service Commission. He was previously a member of the board, Judicial Training Institute, JTI, now known as the KJA, and the chairman of the Kenya Magistrates and Judges Association, KMJA, and treasurer of the East African Magistrates and Judges Association, EAMJA. Until his appointment as a judge of the Supreme Court, Justice Lenaola was the presiding judge of the Constitutional and Human Rights Division at the High Court in Milimani, where he rendered illuminating and groundbreaking decisions on human rights, devolution, separation of powers, and other areas of jurisprudence. In all the stations he served outside Nairobi, he is reputed for his diligence, hard work, and has on many occasions been cited as an example in the best case management and backlog clearance. Judge Lenaola has served as a judge and deputy principal judge of the Court of the First Instance of the East Africa Court of Justice from 2011 to 2018, and as a judge at the Residual Special Court for Sierra Leone from 2013 to date. He is also the president of the Advisory Council at the Strathmore Institute for Advanced Studies in International Criminal Justice and president of International Association of Refugee and Migration Judges. Judge Lenaola is a fellow of the McLaughlin College, I hope I've pronounced it correctly, in Toronto, Canada, a fellow of the Chartered Institute of Arbitrators, a member of the Commonwealth Magistrates and Judges Association, among many other organizations. He was awarded the Law Society of Kenya Award for Distinguished Service in the Administration of Justice, the East Africa Law Society Honorary Membership Award for Exemplary Service, and the Development of Jurisprudence in Kenya and the East African Region 2015, among other awards. Judge Lenaola is a recipient of the Moran of the Burning Spear from the President of the Republic of Kenya for distinguished service in the administration of justice. In 2002, he was awarded the rank of CBS, that is Chief Burning Spear, and has been named Jurist of the Year by the International Commission of Jurists. Ladies and gentlemen, join me as we welcome our keynote speaker, Honorable Justice Isaac Lenaola, representing the Chief Justice.
Good morning, everyone, and thank you very much for the invitation to participate in this very important conversation. I bring greetings from the Chief Justice of the Republic of Kenya, the Honorable Lady Justice Martha Karambu Kome, who's not able to attend, but sent me to represent her, and I hope I shall do a good job of it. Let me also thank the organizers of this 6th edition of the African Law Tech Festival 2025. Linda Bonyo, my friend, CEO and founder of this process, for convening this timely discussion. Maria, thank you very much. Luisa, and the others. Let me also recognize my colleagues on the bench, my colleagues from outside Kenya, Zione, Sylvester, and the others. Let me also recognize my colleagues from the Kenyan judiciary who are here, and also all of you, development partners, government officials, regulators, distinguished ladies and gentlemen, and I wish you a very good morning. I think when I was asked by the Chief Justice to come here, I assumed I was going to speak to the regular 15, 20 people who are techies. So when I was told by Louisa, you may actually be around 500, I was slightly intimidated because you can imagine a judge of my caliber with not much of a techie like yourselves facing you techies and trying to tell them what they should already know because this is your subject, not mine. But here I am, and so I shall do the best of the time I have. 2 weeks ago, my colleague Elizabeth Tanui and I were in South Africa, in Joburg, for a conversation around artificial intelligence and elections in Africa. And one of the takeaways from that conversation was the fact that courts are no longer the traditional courts that I joined when I was admitted to the bar in 1991. Courts are no longer just the temples of justice in the traditional sense, but courts are actually now nodes in a digital system. So that when I joined the judiciary in 2003, any conversation around technology was completely alien. And those of you who've heard me speak before will remember my story about our attempts at introducing PCs to the judiciary. And a lot of judges would look at these PCs as alien devices that look like they've come from another planet. And so the judge would come in the morning, the thing is covered with that nice cover. The judge removes it, puts the cover somewhere, keeps looking at this device from a distance, then does long handwriting through the day. In the evening, you cover it. Nobody wanted anything to do with that thing called a PC. Today, all of us, most of us at least, are able to use these devices. And therefore, the judiciary cannot stand outside the currents of digital transformation, because that is the reality we are in today. In the judiciary of Kenya, we have, amongst other conversations, a transformational agenda where we are saying, through the Chief Justice's vision, that technology is an enabler of justice. And therefore, now, to enter the Kenyan judiciary is an expectation that you have knowledge of or some rudimentary understanding of what technology is about. But we also know that technology is not as straightforward as it should be. And therefore, we know it is a double-edged sword with opportunities and with challenges. We in the Kenyan judiciary have learned that the opportunities we must embrace and take on board our conversations includes the need to use technology to enhance our efficiency, our transparency, and accessibility. For a long time, the Kenyan judiciary and other judiciaries in Africa have suffered the mantra of being called corrupt. And one of the reasons for corruption is because our systems were never transparent. And the more delays we created in making decisions in our courts, the more the expectation that you are delaying judgments, you are delaying the hearing of cases because you are waiting to be reached, to be bribed for you to fast track the case. And therefore, with the transparency, with the efficiency, with the accessibility that is now available through technology, we have learned the hard way in the Kenyan judiciary that this is an opportunity we must embrace. But of course, we also have challenges. And just this last couple of days, we in the Kenyan judiciary have suffered what I'm sure other judiciaries are suffering, which is the risks associated with cybersecurity. Last year, I spoke at a forum like this, and I said, we must start speaking loudly about the fact that our digital processes are susceptible to attacks. And we've learned it the hard way. So that's a challenge we must continue dealing with. There's also the challenge of digital exclusion. I come from the north of Kenya. The north of Kenya is not a regular Kenyan area. We spend our time cattle rustling, and Maria knows this because we speak about them. I tell her that thank God I'm a reformed cattle rustler, and that is why I'm here. We do not have the infrastructure that we have today up there. And therefore, it is very easy for the north and other marginal areas to be excluded because of the nature of the areas we're dealing with. We also have, of course, the fundamental question of ethical dilemmas. Again, whenever I speak to a forum like this, especially to lawyers, and my sister Judge Kenan from Tanzania knows this because she sent me a clip of myself warning lawyers against using artificial intelligence to file submissions before our courts. And as fate would have it, just yesterday, in a group of my university classmates, a colleague did write that an advocate in a town called Nakuru, for those who are not from Kenya, just yesterday was asked by a judge, go and file your submissions within 14 days and come back. The lawyer went, DeepSeek, ChatGPT, produced these submissions to a brilliant, filed them, and then sent a copy to my classmate. And what he had done, he had argued the case for the other side. So those are the risks associated with artificial intelligence when you do not know what you're doing with them. And so my colleague was saying, he filed submissions yesterday basically saying, my lord, I completely agree with the submissions by my colleague because they speak to our case. So these risks are real. The question of digital case management is an issue our judiciary must continue dealing with. So in Kenya, for example, over the last 4 years since COVID, we have introduced a robust e-filing system. And so for us, not just in Nairobi, but every court in Kenya now, we have e-filing of documents, we have e-receipting, we have e-stamping, we have e-payments. And so all our courts are wired, thanks to the work of the likes of my colleague Elizabeth Tanui, our registrar automation, we are able now to move away from manual physical filings of bulky documents, sometimes carried in trucks to our courts. And the benefits of this are obvious to us. We used to take averagely 2 hours, 1 hour, 3 hours to file physical documents. Today, you can file all your online documents, digital documents, under 20 minutes at the very most, mostly 5 to 10 minutes. We also are, of course, it is convenient. Sitting in your office, sitting in a restaurant, sitting wherever, you're able to conveniently connect with the court system. One of the innovations we have done is a partnership with the Office of the Director of Public Prosecutions, where charge sheets are no longer brought physically to court through the Wadilifu system. Your charge sheets are filed to the court, we receive them, we stamp them, we give them a case number, we send them back to you, and the accused persons are brought to court. We are also working, I'm the chair of the National Council on the Administration of Justice ICT Committee, and now we are working towards ensuring that the police, the prisons, probation, and other players, LSK, network with us digitally to ensure that all our operations are conveniently conducted. And I think for me, that is a benefit we must continue to encourage. Transparency. Like I said earlier, the more transparent your systems are, the more the administration of justice will be assured. And because of the digital systems we have created, there's a lot more transparency. For example, one of the difficulties we've had traditionally is where you get a judgment and then the decree is not coming out on time. We are still struggling with that. But in fact, you ought to get your judgment immediately it's delivered because it is transmitted to you digitally as soon as it's delivered by the magistrate. Of course, we have challenges, including connectivity. One of the things we are doing in Kenya today is to ensure that all our courts have solar backup systems so that the question of electricity, the question of power should not be there. We still have issues, of course, with networks, but we have also partnered with the central government to ensure that all Kenyans are part of the last mile connectivity program run by the Ministry of ICT. And we anticipate that by the next couple of months, all our courts will no longer have the difficulties of connectivity and networks. One of the things I must speak about, because you guys are techies and we know what happens, is also the question of decorum in our courts. Because our systems are transparent, our virtual courtrooms are open, we allow everybody to join the court system. But of course, we are struggling with decorum. When people see a judge standing in front of you, like myself, you have a lot more fear. But you digital warriors, you know that your real courage is when you are alone in your small corner and you don't care. But when you are in physical courts, then of course you are limited in what you can do. Two of the experiences that we've suffered in the last 1 year have been embarrassing. One guy exposing himself in front of the Court of Appeal. Another lawyer found in bed with a partner, and we had to struggle to say, please cover yourself. So virtual spaces do create problems. But again, looking at the benefits of what we have received, I think we can deal with the rascals and the transgressors and the miscreants who misuse our virtual spaces. Let me speak a bit about AI and automation. We in the judiciary of Kenya are using artificial intelligence now to pilot the transcription of court proceedings. For a long time, and I speak now both in my past life as a practicing advocate and now as a judge. For a long time, we struggled with court proceedings, both during and after conclusion of hearings. And so a lot of appeals are delayed because of transcription of proceedings. Today, we have a pilot program at the Milimani Law Courts for Other House, where it is possible that after a hearing of a case today, overnight, the AI tool transcribes all the proceedings. And the following day, the transcribers can edit what the AI tool has done, and in 48 hours, you have your proceedings ready for you. And that, for us, is a milestone. We have also identified the Nanyuki Law Courts as the court where our transcription center will be hosted. And we intend that in the course of this year or next year, Nanyuki will have a fully fledged transcription center connected to the entire country. And therefore, within 48 hours, you can have your proceedings ready. If you want to appeal, then you can have the proceedings ready for the appeal. I think for us, that is a good innovation. Number two, of course, we use it for legal research. I have 2 law clerks who work with me, including preparing speeches, summarizing cases for me. But I've warned them, of course, about the risks of legal research that has the use of AI with the result of hallucinations. Last year, we had the Supreme Court at 12 conference, and I was chairing a session of people who were speaking about AI. And I quickly went to ChatGPT and asked, who is William Ouko? Now, William Ouko is my colleague in the Supreme Court. It came in like milliseconds. William Ouko is the Chief Justice of Kenya. He was appointed in 20. Of course, he's not the Chief Justice of Kenya. Just like my brother here, thank you very much for the elevation. I am not the Chief Justice of Kenya. I represent the Chief Justice of Kenya. So we need to ensure that as we use AI for research, we do not we are careful not to have hallucinations take us into where we should not be. In the US, there was a lawyer called Cohen who was President Trump's lawyer. And just the other day, the law firm that was representing him in his cases during the Trump troubles had used AI to generate submissions for a case. And the AI tool generated completely fake cases, precedents, and the court and the lawyer, the law firm was fined $500,000 US by the court for that. In Brazil, a judge called Fernandez, who's known to me, I was with him about last year, Judge Fernandez asked his law clerk, please do for me a draft judgment. The judge, the law clerk did the draft judgment, gave it to the judge didn't proofread it, the judge delivered the judgment. You know that we have now tools that can discover if you use AI. I use it in every single day when I see what I get from my law clerks. It was found that 85% of the judgment was generated from AI, and it was completely false, had nothing to do with the case which the judge had had. And the judge is going through processes of discipline. In Colombia, a similar thing happened. Again, a judge misused AI, and he too is going through disciplinary process. So my call to the lawyers, if there are any lawyers here, be careful how you use AI. It's a useful tool for the work we do, but ensure that it has obviously information that is correct. We also have judicial ethical concerns. Traditionally, Zione, you know that as judges, you own the judgment because it comes from your mind. But now we have this other mind called AI, which can help you generate a judgment. If AI helps you 85%, is that judgment yours or an AI judgment? If you use AI to generate a ruling, and the ruling is 50% you, 50% AI, is that your judgment or shared with AI? So I think it's important that even as we use AI, we, at least on the judicial side, must be concerned about the ethical considerations so that we do not let go of the fact that it is your decision. You've had the case. Because AI cannot see what is called demeanor. Lawyers and judges are trained to see if you are lying. So you can try me at tea time and try if you lie in front of me. AI cannot tell if somebody is lying, but you can. And therefore, how can you use an AI tool to say, Judge Kenan, he's telling the truth or he's not telling the truth? So the ethical concerns are important considerations for us so that the impartiality of a judge is never lost. If the AI tool makes a decision which is partial, do you blame the AI tool or do you blame yourself if you are discovered to have made a wrong decision? So these are important considerations for us as we adopt AI. How has technology affected us as users of the judicial or of the technology ecosystems we use in the judiciary? I have no doubt to myself that litigants, advocates, court staff, registries are all comfortably using technology, and transparency has been enhanced, and public confidence in our judicial system has been enhanced. I can speak with authority about this in the Kenyan judiciary. But what is our role as a judiciary in the adoption of technology? Number one, we struggled initially in creating policies. But now I'm comfortable myself in saying that between 2022 and 2027, the Judicial Service Commission has a strategy on technology. The judiciary has a strategy on technology and spoken about it. And just the other day, we developed a policy on the use of artificial intelligence, which shall soon take ground for public participation. I believe myself that that tool will assist all of us in embracing technology. Like I said, at tea with my colleagues earlier, just 2 weeks ago, we were in South Africa at a roundtable conversation on artificial intelligence and judiciary and elections in Africa. Now, you know that in Kenya, and those of you who are Kenyans know that one of the issues that is becoming prominent in resolution of presidential election disputes is electronic transmission of results. In 2017, I was one of the 4 judges who nullified the presidential election petition, the presidential election of President Uhuru Kenyatta. And we nullified that election for one singular reason, that we could not verify the transmission of electronic results from the polling station to the National Tallying Center. And therefore, the final results that were given by the Chairman of the Electoral Commission could not be verified by the court. In 2022, again, the central question before the Supreme Court was whether the electronic transmission system for the results was verifiable, was legal, was regular. I can assure you, without a shadow of doubt, that in 2027, technology will be at the center of all the election petitions we shall handle as a judiciary. Many years ago, the reasons why elections were being overturned in Kenya was because of use of witchcraft, ballot stuffing, the ballot, actually snatching of ballot boxes. You know, you pick them, throw them into a river, the river goes with them, you say there are no results. It was manual, it was physical, it was stupid, it was wrong. Today, you will not get a petition from where Maria comes from, a place called Ukambani, where witchcraft is irregular, where someone will come and say that this man won the election because he went and put pregnant women, he put 100 shillings and say, if you don't vote for me, you'll abort because of witchcraft. That will not happen. So more and more, therefore, courts must embrace technology in resolving fundamental questions of our democracy, including elections. And the judiciary is prepared for this. We must also speak about capacity building. Judges, staff, litigants must be trained on tech tools. We in the judiciary are embracing this, but I am fearful that other agencies are not moving as fast as the judiciary. The prisons are struggling, the police are struggling, probation is struggling, and we are trying to bring ourselves together through the National Council on the Administration of Justice to ensure that we carry each other along in this journey of technology. The other difficulty we are facing today is the fact that we are not investing enough in technology. So that some years back, we in the judiciary had been allocated by the National Assembly 500 million Kenya shillings to build our technology space. As some of you here may know, I'm one of those judges who makes controversial decisions. I think with age, I become calmer. So I declared a fund called the CDF Fund, Constituency Development Fund. I declared it unconstitutional. And the following day, Parliament took the entire 500 million on technology from the judiciary to punish us for that decision. And I felt very bad because I was just doing my job, but the entire judiciary has suffered because of me. We need to ring fence. We need to ring fence all the budgets on technology in every institution of justice. If we don't do that, then we are wasting time to speak about technology. Because technology is the future. We are not going to go back to manual handwriting, to that those days judges feared PCs. And the only way we can do that is to ensure there is sufficient funding on the technology agenda. And we in the judiciary are very happy that so far we seem to have support in that regard. Gen Z, a lot of you are here. Last year during the withdrawal of the Finance Act, one of the affected agencies was ourselves. We had put aside some money to have our own servers, but because the act was withdrawn by the president, we lost a whole year of technology advancement. But I'm not blaming you. I'm just saying, let us not throw the baby with the bathwater in every instance. That is all I can say because you are my friends. And so today we are trying to use both manual process and the technological processes until we are sufficiently capacitated financially to move our way fully into the digital space. What is my message around all the challenges we have? We must balance innovation with fairness as a judiciary. We must not let ourselves rush into technology but leave behind the court users. We must not, as we innovate around technology, also become unfair, because justice and fairness go hand in hand. And if we don't have fairness, there cannot be justice. And therefore, in all regards, as we embrace technology, justice must be at the center of all our activities. We must also ensure that all the activities in the digital judiciary are human-centered and people-centered. Our constitution is a people-centric constitution. Our judiciary, through the social transformation, access to justice through social transformation, is a people-centric agenda. We cannot afford never to forget that we must be people-centered and human-centered. Courts must also, as they become efficient, as they become inclusive, must become responsive and must remain and retain that responsiveness to the needs of our citizens. If we are not responsive, if we are techies who are in a cloud, who are in a pedestal, who are not capable of coming down to the ground, to the people who don't speak our language, we shall lose the need for us to combine the need for justice and fairness, because we shall be exclusionist, and then we shall be completely useless to our people. And therefore, it is my cry, it is my prayer that regardless of geography or digital access, we must always ensure everybody is in this digital space. What then do I say as I conclude? I invite you, our techies, I invite you, our colleagues in the judiciary, I invite you, regulators, I invite you, policymakers, I invite you in government and civil society, you innovators, bar associations. We must co-create effective solutions. Let us work together. Let us collaborate. Let us engage constructively. Get solutions that are people-centric, citizen-centered. And as I close, let me once again thank you, the organizers of this wonderful conversation, for the opportunity to bring all of you from the 15 African countries that are here to reflect and engage. And on behalf of the Chief Justice of Kenya, on behalf of the Kenyan judiciary, I commit myself and ourselves to innovation, to fairness, and to justice. I thank you for your attention.